Welcome to our show, Onwards and Upwards, everything a global healthcare worker needs to know about living and working in the United States. I am your host, Danielle Chasen, the Director of Special Projects here at Kinetics USA, part of the AMN family, and proud to be part of the AMN family. And today we have a special immigration show. We are going to be doing an immigration update for everybody. I know everybody, like myself, was anxious to find out if the October visa bulletin was going to be released. We're all still waiting, so stay tuned for a special report on that visa bulletin when it is released. But until then, we have our regular scheduled programming, we have our experts, and we are going to be doing an immigration Q&A today. So please put your questions in the chat. Let me know where you're watching from. I love to know where our viewers are watching from and love to make sure that we get your questions answered. So please go ahead and put those in the chat. Before we get started, I wanted to remind everybody of all of the opportunities that are ongoing. We are still filing you. Get your place in line. We have opportunities in every state for direct hire and for staffing with our sister company, O'Grady Peyton. So if you look at that graphic, we cover all of the 50 states. So wherever you might want to go, now is the time. Submit your applications. Our recruiters are on hand. amnhealthcare.com/international to apply to direct hire and to staffing. We would love to help you. Before we get started, I also want to say welcome to any new viewers who have not watched our show before and are newly joining us. Before we get started, we're going to run through what we call our success path. If you have joined us before, you know this graphic, you've seen it. This is something that you can find on our website if you are curious what the process looks like. So let's go through it very fast. So step one is going to be the NCLEX. So this is the first step. If you're wondering, how do I get started? What do I need to do? The NCLEX is going to be your first step to getting started. That's your golden ticket. Once you pass the NCLEX, you are going to move to step two, which is preparing for the interview. This is where our recruiters are going to match you with your perfect match. We work, as I said, in all of the 50 states. So we're going to help you find a good match. Step three is the visa framework. Step four is licensing and credentialing. We are going to help you through the immigration process. You're not going to be alone. Kinetics AMN is there for every step of the way. Step five is the get ready game plan. This is when you have been granted your green card. You do your little happy dance because you're on your way to America. We are going to be helping you through all of the transitions, making sure you're prepared to arrive and set up for success. Step six is the arrival sequence. This is where we are going to pick you up from the airport. You've touched down in the USA, and we are going to make sure that you get set up with housing, with the car loan, with the credit card, all the good stuff that you need to make sure that you can prosper in the US. And then step seven, which is going to be enjoy and prosper. And this is what we want for all of our nurses. So please, once again, if you are interested, today is the day. Our recruiters are on hand waiting. That website again is kineticsusa.com/apply. Okay, so without further ado, let's bring our two expert guests. Morning, Chris. Morning, Mike. Nice to see you both.
Hello, how are you?
Good day. Hello, everybody.
You guys are good. I know we're all anxiously waiting for the October visa bulletin. So before we get started, for any nurses who are newly watching our show, why don't we take a quick second to give a little bit of background on each of you. Chris, do you want to go first?
Sure. Yeah, no, I'm Chris Masillo. I'm here in Cincinnati, Ohio, about 3 blocks south of where Mike Hammond's sitting, but we never do these in the same space. So I've been practicing in this in immigration law for 25 years ago. In May was when I graduated from law school. The majority of that I've been working in the healthcare space, and most of that is with nurses. And so as every month, I'm happy to join everybody and try and provide some information to everybody.
Thank you, Chris. I didn't realize you guys are 3 blocks away from each other. We got to do a little joint session, maybe when we're all in the same room, if I ever make it out to Ohio.
Absolutely.
You need to come out.
Yeah, I know.
Although we used to only be about a block and a half, Mike decided to double the walk by moving his office about a year or two
A
ago.
whole 3 blocks, and you're still not doing it in the same room. One day.
One day.
All right, Mike, go ahead. Give us a little bit of
Yes.
background.
My name's Mike Hammond. As Chris said, I'm much further north than he is in Cincinnati. So it's colder up here. I have been doing healthcare immigration since about 25 years, and practicing immigration in general for like 30 some years, so very long time. And excited to help and be a part of this and answer questions and try to give people some guidance. And if you can see from my label, I'm as excited as you guys are about where's the October Bulletin. And so I've told people, I said, watch for it. We're on this call between 10 and 11. If anything comes up, run in here and interrupt us and let us know. So we're all anxiously waiting. So.
Well, that would be very interesting. Watch that would happen. The U.S. government would do that to us while we're on our live show. They would just release the bulletin. So we'll be waiting for somebody to run in from the corner and be like, it's here,
Right.
It's here. Well, thank you, Chris and Mike. So as you can hear, both Chris and Mike are very seasoned attorneys. They know what they're doing. They know their stuff. We've been working with them for a long time. For anybody who is new to these shows or has watched before, you know that my mom is Tanya Friedman, and she has been working with Chris and Mike for a long time. And now I get the joy of working with them. So let's get started. Let's cover a couple of basics for anybody who is new. So Chris, can you give a little bit of an overview of what the Visa Bulletin is, what we're talking about right now, why are we so anxious for the Visa Bulletin to come out in October, and any other little background that you think our viewers should have?
Sure, yeah. So the Visa Bulletin typically comes out on a Friday in the middle of the month. And so I think most of us are expecting it to come out today. I actually think that there's still a chance that it comes at the end of the day, East Coast time here in the US, although I don't have any real inside information on that. That's really speculation on my part based on past practice. But what the Visa Bulletin really does is it sets the date that your case is able to move to the final stage of processing, which is if you're overseas, your consular or embassy interview. If you're domestically in the United States, that interview takes place here at a USCIS office in the United States. Although in many instances, if your interview has to take place here in the United States because you're in the United States in another visa category, such as student visa or H-1B visa or TN visa or anything else, your visa is often waived, or excuse me, your interview is often waived here in the United States. Not always, but it's pretty common for the interview to be waived. And so the date, which you'll see on the grid, which I'm sure we can put up on the slideshow here, the grid is based on your priority date, which is the date that you have your I-140 filed, or if you're not a nurse, but you're frankly every other occupation out there is a physical therapist, it's the day your PERM labor certification is filed. In any event, that sets your priority date. You then look on the chart, whether you're EB1, EB2, EB3, EB4, EB5, and then you look at your country of birth, not your country of nationality. The system works off your country of birth. And you look at the grid and there will be a date there. And if your personal priority date is earlier than the date that's listed on the chart, your case is eligible for that interview. If it's later than that date, then your case is held in abeyance until such time as the next month and the next month and the next month, until, of course, you are what we like to call current. Last point, sometimes you'll see the letter C put into those boxes. That essentially means there is no retrogression in those categories. And so if you are, I don't know, EB1 other country, I suspect will probably be current when the Visa Bulletin is announced. And for someone like that, then their case there's no delay at all. It just moves all the way through the process.
Okay, thank you, Chris. That's a good little overview. So Mike, what happens if your priority date is not current?
Well, I think it depends upon the stage you're in the process. I think for most people, the fact that your priority date may not be current doesn't change at all what you should be doing. So if you're at the stage where you are studying for your NCLEX exam, or you've maybe already passed your NCLEX exam and you're doing your English exams and processing your visa screen and providing documents to the NVC, You just continue to operate as if you operated. The retrogression and the priority date not being current reflects how long it's going to take you to get through the process, not that you should necessarily stop doing anything. So I think for most individuals, it's status quo. If you were supposed to do X next week, you continue to do X. As Chris mentioned, it simply relates to when that final part of your case is actually concluded. That's it.
Okay, thank you, Mike. So to reiterate what Mike is saying, business as usual. Your filing date is essentially your priority date. That's how you get in line. So you can go through the whole process, take the NCLEX, apply. We are still filing. AMN Kinetics has been doing this for a long time. Chris and Mike have been doing this for a long time. We know how to handle retrogression. We know how to handle this delay. So apply now, get your place in line. Another kind of basic overview question that we've been receiving. Chris, what if you have a previously filed application? Can you recapture that date?
Yeah, no, that's a great question. So if you do have a prior I-140 that's been approved with a different employer, and now you're moving to another employer, you can then, if the new I-140, the second I-140 is prepared properly, you can recapture that old date. So for instance, you were sponsored by a U.S. hospital in, 2018, something happened in your life, you couldn't continue to pursue that case, but your I-140 was approved in 2018. Now we're in 2023, you want to get back into the U.S. immigration process. You reach out to your old hospital and they're no longer interested in pursuing your case. The new 2023 case can be prepared with reference back to the 2018 case, such that when the 2023 case is approved, that approval notice will have a priority date listed on it that will actually be backdated to 2018, which means that if the visa bulletin comes out and your category in the visa bulletin shows, for argument's sake, 2022, you would normally have to wait a year because yours says 2023 and the priority date is 22. But because we've recaptured your date to 2018, you can continue to move forward as if your case, even as if your new case was filed way back in 2018.
Okay, thank you, Chris. So that's some good background for our viewers, for anybody who is new to our shows. If you have any questions, Chris and Mike are here. And they are ready and waiting for your questions. So let's turn to some of these comments. Let's see what questions we have in the comments. So Tatenda is saying hi from Swaziland. Hi, Tatenda. Eros is saying hi from Saudi Arabia. We have peace and tranquility, eagerly awaiting. I am also eagerly awaiting, as are Chris and Mike. So I see a question from Jeff. Jeff says, are there any opportunities for an Australian to work in California? So I think I'm going to take that question. Yes, Jeff, good news for you. We do have employers in California that are hiring for nurses that are hiring right now. So now is a good time to apply. Kinetics USA for kineticsusa.com/apply. Arlene from Jamaica is saying hi. I see we have a question from Emily Marshall. So Mike, do you want to take this one? Emily is saying, how soon after you file your EAD can you request an expedite based on being a healthcare worker? Can you request it before biometrics are done?
So what she's talking about is an individual who's here in the U.S. and has filed an I-45. So they're presumably in some other visa status, student or something else, and they're basically doing their green card process through the U.S. 485 process. And there's a USCIS policy that says EAD cards can be expedited under certain circumstances, and one of the circumstances is certain healthcare workers. The expedite request can be put in as soon as you have a receipt number so that you can actually reference something. Generally speaking, you can only put in an expedite request every 30 days. So waiting until your biometrics are done may be a wise decision. However, keep in mind, they can often get biometrics from a variety of different sources. but generally we've been putting them in after we get the receipt. Right now, there seems to be a little bit of trend. If you are an F1 student and you have an OPT EAD card already, that they're not going to entertain an expedite request until you're within 30 days of it expiring. So it depends a little bit on Emily's situation, but that's generally how we would handle them. And they've been fairly successful. Very rarely are we not getting EADs expedited for healthcare workers.
Okay, well, there you go, Emily. There's some good information for you. So Chris, you have a question from Chia Victory next. Chia Victory says, I'm watching from Nigeria. Hello, Chia. What if my spouse wants to join me after 2 years? Is that possible? How do I go about that?
Generally speaking, yes. The key thing is that you are married at the time that you receive your green card. So let me just go through two scenarios which might explain this best. So one scenario is you're married at the time of your green card interview. Let's pretend your green card interview is Manila for this example. But for life reasons, your spouse wants to stay back in the Philippines. Perhaps they have a job there. They want to, maybe the kid's finishing up high school, something like that. So you come to America, and then 2 years later, the plan is now your spouse is going to come to America. We would do a process called a follow to join in many instances. And that spouse then would go to an interview in Manila, and he could enter the United States. That's fairly straightforward. Something that's a little more difficult is if you're not married at the time that you get your green card, you come to America, that 6 months later you go back again, maybe to the Philippines, you marry your spouse, then you enter the United States. Now your spouse has to go through a different process, which candidly can take longer because you were not married at the time of the interview, and so that's how that would work.
Okay, thank you, Chris. So we have another question. I actually see this question coming up a lot. We've discussed it on our shows. So Mike, we have this question from Sabine. Sabine is saying she's already doing her consular process. Can she also do the TN visa? So is it possible to do a concurrent filing?
If she already has an I-140 approved, which would seem to be a part of her, and her party date's current, then she's going to have trouble getting a TN because of the fact that she's going to be immediately eligible for adjustment. However, if her party date is not current and she's not immediately eligible for adjustment, then she's likely not going to have an issue in getting a TN at the border. So it depends on her particular circumstances. There's also certain border crossings that are going to be better than others for situations like that, and she's going to need to be kind of coached. The idea of a TN is a non-immigrant intent, which obviously if you filed an I-140, you're indicating immigrant intent. However, the non-immigrant intent relates to this specific entry, and if your party date's not current, then you don't have the immigrant intent at this particular time because it's not even possible. So it can be done under the right circumstances.
Okay, thank you, Mike. I think a good takeaway I've learned from doing these shows with both of you is if you are watching, consult with your lawyer first before you do anything. You don't want to be making any mistakes. Leave it to the experts. So that's why we work with Chris and Mike. They know what they're doing. So we have a question from Anya. Anya is saying, what about medical technologists or medical lab scientists? I think she's asking, what are the options for a medical technologist or a medical lab scientist? Chris, can you take this one, please?
Yeah, broadly speaking, there's two or maybe a third basic approach that most of our med techs come into the United States. One way is the H-1B visa, which is not that often, but sometimes available for nurses, but is almost always available for med techs. The H-1B visa has a lot of perks. It's generally much faster than the EB-3 green card being the main perk. But it's got some downsides. Sometimes it's subject to the H-1B cap or what's called the H-1B lottery. Sometimes spouses cannot easily get work authorization. But that's one path, is the H-1B. The second path is the EB-3, which looks a lot like the nurse process with one big difference. Before we're able to file the I-140, we actually have to file something called a PERM, which frankly adds an extra year to the process. Now, depending on retrogression, that year might not ultimately mean a year to your particular case. I don't want to get too technical, but that's a second path, which is a PERM EB-3 process. The sort of sometimes path is there are a few trade visas out there. The most common one is called the TN visa, which is for Mexican and Canadian nationals. And there's a few other trade visas called either the E3 visa, which is for Australian nationals, and the H-1B one, which is for Singaporean or Chilean nationals. But outside of those 5 countries, Canada, Mexico, Australia, Chile, and Singapore, the most common pathways are the H-1B and or the EB-3.
Okay, thank you, Chris. So there you go. There are the options for medical technologists. Okay, let's turn to the comments and see what other questions we have. So we have Teika, who's watching from Bahamas. Hi, Teika. We have Nana, who's watching from the UK. Sophia, who's watching from Philippines and just passed her NCLEX. Congrats to Sophia. That is very exciting. So I see a question from Donsky. Donsky says, is it okay to pay the fee bill even if my priority date is not current? Mike, do you want to go ahead and take that one?
I think you want to talk to your case manager to determine what the policy is going to be for you and your hospital and the agency as to whether they want fee bills paid if your priority date's not current or not. So it's not a legal question because, of course, it's totally fine to do that, but there may be reasons why you don't want to do that. So I would talk to your account manager or case manager, whatever, to determine whether that makes the most sense for you.
Okay, thank you, Mike. Good advice. As I have said, consult the experts. The experts are also your attorneys and your case specialists. So if you have any nuances in your case or any questions, you can always consult your Kinetics case specialist. So I see that Francis has a comment. Francis says, wow, seeing many RNs watching from different parts of the world. Will the USA healthcare be able to accommodate all of us? I know, Francis, isn't it amazing? I'm seeing so many countries on here, so many people watching from all over. The good news is, yes, we will be able to accommodate. We have thousands of open positions at AMN between Kinetics and our sister company, O'Grady Peyton. So yes, we will be able to accommodate, and we are excited for you. So that's some good news for you, Francis. So Sabine has a follow-up question for you, Chris. You were talking about recapturing your priority dates. Sabine says, how much time does it take to recapture your old I-140? Do we have any estimates or guesses?
So I guess really the answer is 0 days. It happens at the same time that new company's I-140. I'm hearing some feedback. I don't know if anybody else is, but just wanted to bring it up.
I don't know if I'm hearing any feedback on my end.
Okay.
Hopefully the feedback will wait for you. Okay, so thank you for that, Chris. So that's good news for Sabine. Abu Bukhari says, I am documentarily qualified, but I saw the wrong spelling of the surname of the birth certificate of one of my dependents. Do I need to do anything about it? Mike?
I'm assuming, by the way, Chris, I am hearing the feedback as well. I am assuming that you haven't had an interview yet. I would try to get the birth records corrected and bring with you to the interview. You also want to check and see what did that create a situation where the passport name may also be the passport name will come from the birth record. So you want to check that. I would try to correct that and bring that to the interview with you.
Okay, thank you, Mike. So it sounds like a lot of people are hearing the feedback actually. So hopefully that corrects. Sorry about that, everybody. So let's see, what other questions do we have in this chat? So I see a question from Debbie. Debbie says, my children are on my DS-260, are followed to join. When will it be possible to start the process for them to come to the USA while in the USA? I don't know if I totally understand that question. Do either of you understand that question?
I mean, I think the short answer is this is, follow to join isn't terribly complicated, and it's legally pretty straightforward. Having said that, I think with follow to join, you probably want to bring in your attorney on your specific case, especially when you're talking about timing, because the timing is very important. And there's a few specific elements that we would need to know the answer to before we give a specific answer, which is again why I'm going to push you back to your immigration attorney. One key thing will be that they need to have a current priority date as well, and the priority dates have obviously moved quite a bit since April. But I mean, the shortest answer is we always want to begin that as soon as you're ready to begin it. There's almost never a reason to slow anything down in immigration. The answer to any of those, when is the right time to begin this, is almost always today.
So I'm seeing a couple of questions in the chat about Kinetics and O'Grady GP sisters. If yes, what are their individual roles? So I think you're referring to when I said that we are sister companies styles. So at AMN, which is the largest healthcare staffing organization in the US, we have Kinetics, which does direct hire. So those are permanent placement jobs. And we have O'Grady Peyton, which does staffing. So whichever option you would like to do, we can do that for you at AMN. So we have a whole show, if you look back in our shows on the Kinetics Facebook page, on what the differences are between direct hire and staffing and what the similarities are. So you can go back, you can learn all about that, learn all about Kinetics, learn all about O'Grady Peyton, and then apply to the one that you think is going to work out best for you. Our recruiters can also help you figure that out if you're not sure, which I'm sure a lot of you might not be sure. So we are experts at this. We know what we're doing, and we can help you figure out which pathway is going to be best for you. Again, that's amnhealthcare.com/international. You can find out more and apply online. Okay, so Mike, I see we have a question from, let's see, whose question should we take? So many questions. From James. What to do if I lost my passport containing a US visa? What can James do? Is that going to be a problem for James?
It depends on whether James is already here in the US or not. So if he came to the US and already entered the US and now he's lost his passport, the fact that he had a visa in it is irrelevant, because he should be getting his green card mailed to him. And then once he gets a new passport, he can simply travel using the new passport and the green card. If he has not yet entered the US, so he had his passport, got his visa stamp, lost it on the walk home, then he needs to get a new visa stamp in a new passport before he can enter the US. And that's going to be done through the US consulate. The same place that issued him the first visa is going to ultimately issue him the second one. And so he definitely wants to reach out to his case specialist and his immigration lawyer to help facilitate that. But it depends on where James is at now, whether it matters.
Okay, so James, if you hear that, it just depends where you are located, if you're inside the US or outside the US. So we have a question from Janet. Chris, I'm going to turn to you. Janet says, I'm a registered nurse and my employer is now working on my I-140, and my husband is also being started on the H-1B visa. Can we do that concurrently?
Yes. One word answer.
There you go. All right, there you go. So you can do that concurrent filing, Janet. You can see what's going to work out better for you. And how does that actually work, Chris? Let me ask. So,
yeah, I mean,
with that.
Yeah, no. So the first part of it is they're kind of two different cases for at least two reasons. One's an H-1B, one's an EB-3. The second, of course, is that The H-1B is a bit unique. It's different than, for instance, the student visa, in that the H-1B allows what's called dual intent. So for a lot of non-immigrant visas in the United States, the applicant, as they're going through the process, is stating either explicitly or implicitly to the U.S. government that they, the applicants, have no intent, they do not intend to become U.S. permanent residents. And it's a bit of a legal issue, so I wouldn't be too concerned about that, although you want to get your immigration attorney, of course, involved to explain some of the nuance there. But in any event, there's no nuance with the H-1B because that rule is waived for the H-1B, which means you can have dual intent, which essentially means that you can be coming to the United States planning to be here temporarily, which is the H-1B visa, and yet at the same time you have a second intention, which is to get U.S. permanent residency. So that's how that works.
Okay, interesting. I always learn new things on these shows, so that is good information to learn. So Chris, just because you were talking about recapturing priority dates, we have a follow-up question, another one from Mitch Adventures. Mitch is asking, if the EB3 application status is showing expired, is there still a possibility of capturing the priority date?
So there's no such thing as an expired immigration. I shouldn't say that. I'm not sure what he means by expired, the immigration status. The status that one would get off of the USCIS's website would usually only say pending, approved, or perhaps revoked / withdrawn. If he means revoked and withdrawn, it is still often, but not always, possible to recapture that old I-140. But that's surely something you're going to need, not just an immigration attorney, but someone who has experience with recapturing dates with withdrawn or revoked I-140 petitions. So that's the answer.
Okay, thank you. So hopefully that was helpful information for you. So Amy has a question. How do I adjust my green card when I fall out of status? So maybe she's here and her visa has expired. I'm not sure if I totally understand that question. Mike?
Yeah, no, I think let's make an assumption that she's saying, I want to adjust my status, but I'm out of status. And therefore I cannot. So how can I fix that? And the answer is fairly complex. It's very, very fact specific. So you definitely are going to want to talk to your immigration attorney about this. But generally, the easy answer, or short answer, is you got to get back in status. How you get back in status is dependent upon what visa status you were in that caused you to go out. So if you're in F1, there are reinstatement options that may or may not apply to you. If you're H1, maybe it's as simple as getting a new H1 and traveling out, traveling back. However, traveling out doesn't always solve the problem because you've been out of status for more than, say, 180 days. You can subject yourself to a 3-year bar for traveling out, trying to travel back in. So it is certainly possible to get back in status, which would then potentially enable you to adjust your status. However, it's not always the same answer for each person. So definitely talk to whoever's sponsoring you and their immigration attorney, and they will be able to kind of guide you. For some people, there's not an option of getting back in status. You just cannot, which means you would not be able to adjust your status in the U.S. That does not mean you could not get a green card. It just means that you could not adjust in the U.S. You may have to do something called consular processing. And that's a situation where you would travel overseas as if you had been overseas the whole time and finish your green card processing there. Now, the fact that you've been out of status in the U.S. may still play a factor in that. We talked a little bit about the 180-day rule or 3-year bar, 10-year bar. There's a variety of other factors that you're going to have to deal with because of what you did to get out of status. But there are at least options for you to explore.
Okay, thank you, Mike. So Amy, you're going to want to explore those options with your attorney. You want to make sure you're consulting the experts. So I see a question here from Youssef. Youssef says, is Kinetics have a PWD to make the petition for I-140 for nurses? So yes, Youssef, good news for you. Our employers that are going to be filing your I-140, remember we are direct hire, they all have their prevailing wage before they do recruitment. So you can rest assured as soon as you go through our interview process, our employers already have their prevailing wage and they can immediately file for you. The same goes for O'Grady Peyton. If you're interested in staffing, they also already have their prevailing wage, so they are able to do the immediate filing. So that is good news for all of our nurses who are curious about the prevailing wage determination and are interested in applying and having immediate filing. So, Chris, I see a question from Jim. Jim is asking, can you tell us about the green card lottery? Is that an option for nurses?
Could be. Candidly, we don't do a lot of the green card lottery work anymore at our law office. So it's been a little while since I've looked at it. Broadly speaking, the idea behind the green card lottery is if you're from a country that does not normally send a lot of people to the United States to immigrate, and you have a clean criminal record and you have a high school diploma or the equivalent in your country, you can apply through the State Department's website for a green card lottery. Essentially, you put in, you get a lottery ticket, and then once a year, the U.S. State Department runs that lottery and awards, frankly, just a green card based on those light criteria. I'm almost certain, though, for a lot of the countries that are on this call, they probably do not meet the standard for green card lottery because, for instance, the Philippines does send so many people to the United States.
Very interesting. I remember the green card lottery from when I was growing up and when we were trying to immigrate to the United States from South Africa. So that is interesting. Maybe an option for you, but sounds like you are probably better off going through the EB3 green card, which is actually a unique green card for nurses. So you can find out more all about why it's unique on our website. We have special guidebooks to walk you through the processing, but good information for our nurses. So Mike, I see a question from Burke. Burke says, can I get a green card if I overstay my visa?
It depends upon how long you overstayed. If you came in on, let's say, a visitor's visa and you overstayed for more than 180 days but less than a year, you can go overseas and await the end of a 3-year bar, and then you can immigrate to the U.S. If you've overstayed for over a year, it's a 10-year bar. So it is possible that you can, at some point in the future, get a green card even if you've overstayed.
Okay, well, there you have it, Burke. There's some information for you so you can make a good decision. So Francis is asking for some clarification on this concurrent filing that we are talking about. So Francis is asking, hello, dear immigration consultants. Please, did I hear that while you are documentarily qualified and awaiting visa interview, but case is retrogressed, you can apply using a different route to enter the USA? For example, H-1B, F-1, or tourist visa route when necessary. Chris, do you want to answer that one for Francis?
Well, so a couple of things. So yes, H-1B, often no F-1 or B-1, which is the tourist visa. That's the short answer. The longer answer is, even if you can do something, that doesn't always mean it's the right idea to do something. So you want to look at timing, you want to look at your priority date, you want to talk to lawyers and or employers or recruiters who've been through this process that can probably guide you on the best way. One thing I sometimes say to clients is, let's not confuse a lot of action with progress. So just because you can file another pathway sometimes doesn't really mean it makes a lot of sense. So, but in any event, sometimes you can the H-1B, sometimes you can the F-1. Rarely would we, in fact, we would almost never advise someone to enter the United States on a tourist visa with the intention of adjusting status.
Okay, well, there you have it, Francis. Hopefully that is some good clarification for you. As always, consult with your attorney. Leave it to the experts. Let them help you figure out what's going to be the best path for you, the best path for your family. So Mike, we have a question from Helen. Helen says, can we get a green card for our nanny? So maybe you can explain to Helen who will be eligible for a green card.
Yes, a nanny would not count as a dependent for coming in as a green card holder. There are certain U.S. visas that when you come in, that you can bring your nanny. There are other circumstances where you've been, say, a U.S. executive who's been working overseas for a period of time, and you can bring your nanny in if you're being redeployed back to the U.S. Ultimately, when you're in the U.S. as a green card holder, you could potentially go through sponsorship and try to sponsor your nanny. However, those take a very long time and are very expensive to do, and generally are not available for most individuals for the variety of reasons, including wages and other things like that. So the general answer is no.
Okay, thank you, Mike. So we're sorry to be the bearer of bad news, Helen, but the good news is that you can bring your family, your spouse, and any kids under the age of 21. So hopefully at least that is good news on the green card. So I see a lot of questions in the comments asking for predictions for the October visa bulletin. I wish that we all knew. I wish that we had the bulletin. We are all eagerly awaiting the visa bulletin. And once we have the visa bulletin in October, we will be hosting a special Kinetics show. We'll have Chris and Mike on, and we will talk about all of the implications. So everybody's crossing their fingers, hoping for the best. And we will see what happens when we get that visa bulletin. But until then, we're not going to speculate on what we think it could say. We'll just cross our fingers and keep a lookout. I know I have the tab open and I keep hitting refresh, as I'm sure a lot of you do too. So, yep, Chris, and I'm sure Mike too. So we'll wait and we will see what happens. And then we will have our special show to go through the implications of that visa bulletin. But just to reiterate what we talked about at the beginning of the show, Kinetics, AMN, Chris, Mike, we've all been doing this for a long time. We have a lot of experience handling the registration. Get your place in line. That is really your takeaway from today. Your priority date is your place in line. We are still filing people, so apply. Now is a good time to apply. Get your spot. And again, that website, let's pull it up so that everybody can see, kineticsusa.com/apply. So our recruiters are on hand. They are waiting. They are excited to help you. We have thousands of open positions. Many hospitals all across the country are still very actively hiring. So now is the time to apply. So let's turn to a couple more questions. Okay, so Jerome has a question. Jerome says, can undocumented immigrants have their own business in the U.S.? Chris.
If they're undocumented, they sort of legally can't really do anything in the U.S. Having said that, that's probably it's not an immigration question, I guess, is really the answer, because the immigration question ends with we're undocumented, unfortunately. So there may be some states that allow. So the legal system's complex in the United States, as it probably is in a lot of places. We have a state system and a federal system, and then even within a state system, you can have local laws, cities and counties and some of the smaller government jurisdictions. And so those various states might allow undocumented folks in the United States to own businesses, but none of that's going to change the issue that I practice and Mike practices in, which is that none of that's going to really help your immigration case.
Okay, thank you, Chris. A little bit of a not totally related question, but hopefully a little bit of clarity for Jerome. So I see a comment here that made me happy. I see Anthony says, Danielle, you're doing a great job. Thank you, Anthony. How is your mom? Hi from the Philippines. My mom is doing great. So I will tell her that you asked about her, Anthony, as I'm sure a lot of people are thinking about her, and I appreciate your comments. So I love doing this, and I love being here with all of you, making sure that you get your questions answered and meeting a lot of you throughout your processing. You all inspire me, as I'm sure you do, Chris and Mike. So I know we're all really happy to be here and all really happy to give some time to answer questions. So please, if you have any questions, I see there's lots of questions about predictions. So we're not going to take any prediction related questions because we're all just going to wait and see. But if you have any other questions, please feel free to put them in the chat, and I'm happy to answer them. Okay, so Gary says, is there any update about the Healthcare Workforce Resilience Act? So Chris or Mike, I'll let whoever wants to answer this one. Go.
Chris is the expert in this. So.
All right, Chris.
Yeah. So, we had the Healthcare Workforce Resilience Act last term. It received 26 senators, which is about a quarter of the U.S. Senate, a mix of Democrats and Republicans, which are the two dominant political parties in the United States. In the lower house, the House of Representatives, we had 60 or 70 House members who were original co-sponsors. Those co-sponsors also were a mix of Democrats and Republicans. But since that did not pass by December 31st, 2022, it expires, as does all legislation that is not passed. We're now in 2023, and my sense is we're going to have some exciting news in the next few weeks, but some details are still being worked out.
Okay, thank you, Chris. Well, I guess we will all await to see what happens with that. But we appreciate all of the efforts that are going on with that Healthcare Workforce Resilience Act. So I guess let's wait and see. Mike, Yemi has a question. Yemi is asking, should the visa screen be done before filing the DS-260, or can the visa screen process at the same time as the DS-260?
As long as you have the visa screen before your interview, you're legally fine. However, there are a lot of employers that will recommend not paying fee bills until you have your visa screen in hand, particularly if the delay is you haven't passed an English language exam. So there are some practical considerations, but from a legal perspective, it's perfectly fine to do them concurrently. And as long as you have your visa screen in hand by the time you go for your interview, you're fine.
Okay, well, there you go, Yemi. So you want to take into account the practical considerations. It's not just what might be legally okay. You want to take into account what that means for you and your processing and your case. But good news, you can, and either way it works. So I see a question from Christopher Kwame. Christopher is asking, how long after entering the U.S. on an EB-3 can you file for a visiting visa for your parents? Chris, do you want to take that one?
Sure. So you don't file a visiting visa for one's parents. A visitor's visa is a self-petition, and so your parents file for their own visiting visa, and they can do that before you begin the green card process, during the time you're doing the green card process, after you do the green card process, or after you're in the United States. So that's the first point. Second point, we do sometimes find that for a visitor's visa, it's helpful for the petitioner, when they go to their embassy interview, to include information explaining how, for instance, the family is going to pay for their trip to the United States, how long they're going to come, where they're going to be staying. And it's our experience that information like my son or my daughter lives in the United States with their family, I'm going to stay at their house, they're going to pay for the month or two that I'm going to be in the United States. Those kinds of things can be helpful, but technically speaking, it's not a sponsorship. It's a collateral information. It's additional information. So that can be helpful. One thing to keep in mind is if you have a green card and your parents are filing for their visitor's visa, parents and you should not assume that your parents are going to come to the United States on their visitor's visa and then they're going to somehow get a green card. That would be the immigration intent issue that we talked a little bit about earlier in the call.
Okay, so with immigration, it's all about intent, as we keep saying. To kind of follow up on that, Chris, what, if any, are the options of getting a green card for one's parents? How does that work?
So you need to be a U.S. citizen to file for your parents' green cards, and you can become a U.S. citizen. There's some broad rules, and again, this kind of thing you probably want to bring an immigration attorney involved, but just to give a few of the key tips, but not all of them, You need to have been a U.S. green card holder for 5 years. So so if you entered the United States on a green card on January 1st, 2024, you're basically eligible to become a U.S. citizen on January 1st, 2029, at least now. And for a long time, you can file that case a little bit earlier, 90 days earlier, but essentially it's 5 years in the United States. 2.5 years of that 5-year period, you have to have physically been in the United States. And so that's a second rule. There's a variety of other kinds of rules. I'm not going to go through all of them. But so those are a couple of the big ones that we usually point out are the 5-year rule and 2.5 years physically in the United States.
Okay. Well, that's good news for anybody who's watching and thinking they might want to bring their parents. My mom actually brought our grandma on a green card who was approved last year. So it happens, it works. I am living proof of that. So that's good information and something for a lot of our nurses to potentially look forward to. A long road, but worth it at the end. Okay, so Mike, we have a question from San. San is saying for individuals with a B1, B2 visa who got stuck with a non-current priority date, can we still travel to the US through a B1, B2 visa?
So the answer is yes, you can. However, it will have nothing to do with your immigration process for getting a green card. So if you've got a family member here in the US and there's a wedding coming up or there's a graduation and you want to come in for that graduation and that wedding, then yes, you can present yourself to the border and explain, I'm coming here for this wedding, the wedding's such and such date, and I'm leaving 2 weeks afterwards, and that'll be fine. The border always has the discretion to go, we're not going to let you in anyway, even though you have a visa. But generally speaking, for very defined events like that, weddings, funerals, graduations, you can generally come in. However, that's not going to lead to a different path for the green card. Coming in, as Chris mentioned earlier in the call, the idea is intent. So if you come in as a visitor visa and then all of a sudden the priority dates move forward current and you want to now think you're going to have a path to file your adjustment of status, that's probably going to be quite difficult for you to do. And you're likely going to have delayed your ability to actually work. So you want to be careful that you're not thinking of entering as a visitor to facilitate getting your green card any faster. That will likely not be the case. It'll be the opposite. But for very specific things, you
can. Okay. Thank you, Mike. Okay, so we just have a few more minutes, so we'll try to take a couple more questions. So we have a question from Nana who says, how long does it take for an I-140 processing after an RFE has been requested and submitted? So maybe you can just talk a little bit about the I-140 processing. How long does it take to get an approval? And what is premium processing? I know it's a big question, but maybe just a little bit on that. Chris, you want to take this?
Yeah. So the I-140 is filed. There's a lot of things that have to be prepared beforehand, but we'll just limit this to the I-140 part of it. When your I-140 is filed, it can be filed one of two ways. It can be filed regular processing or premium processing. Regular processing, the variance on that timeline at different points of the year and different service centers and a variety of other things make it make it difficult to sort of tie down a timeline. So let's just talk about the premium processing. If your employer elects to file your case premium processing, ordinarily within 15 days, you or the employer will receive one of two things, either one, an approval notice, or two, what's called a request for evidence. Then you're given 87 days, or your employer is given 87 days to respond to the request for evidence. And we see requests for evidence for a whole slew of reasons. Sometimes they're very straightforward. Maybe the U.S. government asks for a cleaner copy of your passport. So that's pretty easy. We get the cleaner copy of the passport. We respond to the RFE. That can happen, obviously, fairly quickly. Sometimes they're way more complicated. They want to know more information about you as the nurse. They want to know more information about your sponsoring entity. And depending on the complexity of it, may take weeks or maybe 86 of the 87 days to prepare the reply. There's a reason the government gives us 87 days standard, and that's because some of these issues are complex. And it's as I often always say to clients, we'd much rather the process takes a little bit longer but gets approved, because no one benefits from a fast denial. However, once you file that RFE reply, in most instances, if it's filed under premium processing, the U.S. government will issue the response to the RFE reply within 15 days, and that will either be an approval notice, or it could conceivably be a denial, or in a very tiny percentage of cases, we'll even get a second request for evidence.
Okay, there we go. Lots of good background, so everybody knows how the I-140 filing works. So we're going to try getting a couple more questions. So I see Sangeeta is asking, what if I don't have experience? So good news for you, Sangeeta. Both Kinetics and O'Grady Peyton have employers that are willing to take nurses that don't have experience. So you can apply on our website, amnhealthcare.com/international, and our recruiters can discuss your options with you. But some good news for you. Okay, so Enoch says, my dependents are a follow to join. Can I change to a company when I'm scheduled for an interview? Mike, I'm going to go ahead and take that one.
Not completely positive I understand the question. So it sounds like he's looking to change jobs while his kids are still in the process. It's kind of what I'm guessing. Does that look like?
I think he's saying that he had planned for his dependents to come later, follow to join, but now he wants his dependents to come with him at the time that he immigrates.
Okay. So if he has not had his interview yet, then depending on what he's done with the kids' NVC process and DS forms, he can likely get that changed so that they're no longer follow to join, but can be included in his process. So he wants to reach out to his case specialist, who will reach out to the attorney to make that happen. But yes, that can be done. You can switch gears, and it can go both directions.
Okay, well, there you go. Good news for you, Enoch. You can talk to your case specialist, and they can help you figure out how to switch that around. So we are almost at the hour. I know there were lots more questions. We'll save them for our next immigration update. As a reminder, we are all eagerly awaiting the October visa bulletin, just like you all. And as soon as we have that, we're going to have a special report. We're going to talk to Mike and Chris, get their thoughts, get their feedback. So look out for that show. We'll all be on the lookout for the visa bulletin. Thank you to Mike and Chris for joining me today. As always, appreciate your time. Before we go, we're going to pull up our schedule for the next Kinetics shows, Onwards and Upwards shows, every Friday at 7 a.m. Pacific Standard Time. So next week, we are going to be doing a stateside show on the Great Lakes states. On October 6th, we're going to be talking about taxes in the USA. I know taxes are these big, scary things, so we're going to help demystify what that looks like. On October 13th, we are having a healthcare facility showcase for Northside Hospital. They are going to be doing big hiring events, and we want to showcase all of the amazing things that are happening over there. We also have our Kinetics College shows, which are every Monday at 6 a.m. Pacific time with our partners, Aspire RN, Swoosh, 9.09, and MyPass. So make sure to take advantage of these free Kinetics College shows. We also have our Kinetics initiatives. So this is everything that's happening at Kinetics. For all of our nurses, if you are in the Kinetics pipeline, you can avail yourself of our free English scholarship. So this is something that is our gift to you. If you need to take the English exam, we will help put you in a free review course, and we have a lot of success with that. We have our $1,000 referral fee. So if you know any nurses who have NCLEX, refer your friends, your colleagues, and get that referral fee. It's extended until the end of this year, so you can take advantage of that by submitting your referrals on our website. We also have our podcast, Nursing in America. We have a nurse aid program, so if you're interested in that, you can apply online. We have our Onwards and Upwards live show, which is our free show every Friday. For global RNs coming to America, our Kinetics College. And then we are also doing allied hiring. So if you are any one of these specialties listed over here, medical lab technologists, feel free to apply on our website. Our allied recruiters are waiting and excited to help you. So that is kinetixusa.com/apply. Once again, thank you, Chris and Mike. I'm sure I'll be seeing you both very soon. Fingers crossed for some good news. Thanks for your time on Friday. And thank you to everybody watching. Onwards and upwards, everybody. Bye-bye.
Have a great weekend. Bye-bye.
You guys.